Case number 16 CR 0100, State of Ohio versus Lloyd Smith. Are you Lloyd Smith?
Yes, sir.
Mr. Smith's present, custody the sheriff, or probation officer Bolster, present on behalf of the county probation department. Smith was placed on written control, 2 counts of forgery with 3 penalties. Originally on December 22nd, 2016, and there were some modifications on March 28, 2018. The defendant declared the responder on July the 8th of 2020. And a warrant was issued for his arrest, and he was taken into custody on the 13th, it looks like. Almost everyone. All right. Now, the notification filed by the probation department, Mr. Smith, alleges that you have failed to comply with the orders of December 22nd and March 28th of 18. Rule 2, that you have failed to report since March 31st, 2020. Rule 15, that you failed to make any payments towards your fines and costs. Rule 18, that you still owe $200 in restitution. Rule 20, that you have failed to complete aftercare after completing the STAR program. You need to provide proof of that. Now, this was signed by Officer Kelly on the 28th, and I have looking over to the left-hand side of the line for the defendant's signature, and looks like it's Lloyd Smith. Did you sign this?
Yes, sir.
On the 28th as well?
Yes, sir.
All right. And you listed your address as 326
South MacArthur Way.
MacArthur, okay. All right. Mr. Smith, the 2 counts of forgery are 53 penalties, and if carry potential jail or prison term of between 6 and 12 months each, or a total of 24 months, fine of $5,000. Now, you're entitled to have a hearing on these allegations, in which the state will be required to have testimony and evidence that proves to the court's satisfaction that you failed to comply. You have a right to have a reasonable period of time to prepare for the hearing. This is a hearing simply to inform you what you're charged with. It's not the intent to be the final hearing. Usually that's set about 10, 14 days after you're notified, to give you time to prepare for the hearings, witnesses, and that type of thing. As I said, can submit the witnesses to testify for you, just like the state can for them. Any event that you're found to have violated these conditions, one of 3 things can happen. I can continue to control the same conditions previously ordered. You continue additional conditions, which includes extending the total term to 5 years. The third and the most serious is I can revoke you and sentence you to prison for 24 months and fine you with $5,000. Now, you are entitled to have a hearing, or to have an attorney to represent you in this matter, to assist you in preparing for the hearing, to represent you in that hearing, to cross-examine witnesses, to present testimony for you if you have any, to subpoena witnesses, to advise you about what your options are and what the processes are, and likelihood of outcomes, etc. If you do not have the funds to hire an attorney, the court will appoint one for you at no cost. Now, I don't have a financial disclosure form from you, so are you requesting that the court appoint an attorney to represent you?
I was never asked any. I was just hoping to get taken care of today, if we could.
Well,
But they never presented me.
the first question is,
Sorry.
do you wish to have an attorney?
No.
Because, this is your this is your second time violating, allegedly violating. It hasn't been determined yet. But I know that we did have one on you for over a year. And so, I haven't taken a look at your file or anything. But, you know, there's a very good possibility you could go to prison. So, you know, the question is whether you want to have an attorney to represent you, you know, in this proceeding to, you know, help you decide what you should do, and to advocate on your behalf, or do you want to go forward without it? Because, and if you don't have the money to hire one, I will appoint one. So, you know, there's no problem there. And that's up to you. It's not going to bother me one way or the other.
I would just like to get it taken care of, if we can, just.
Well, I mean, I couldn't mean, if you get it taken care of, it means you couldn't be, you go to prison. You understand that?
And I should probably get a lawyer, huh? Yeah.
Okay.
I should listen to what you're saying.
All right, well, then, if that's, and I, you know, I have a problem with that. Certainly a reasonable thing to do. So, you'll need to, fill out a financial disclosure form. I assume you don't have the funds to hire an attorney yourself?
I do work, but as far as like now being in jail, no, I still have a job, but not the funds.
Where are you working?
ADN.
Where?
ADN in Greenfield.
How long have you been there?
I've been there 4 months.
Okay.
And on that restitution,
Hold on.
I'm sorry.
You need to not talk because, you know, that issue is something that's worth hearing.
Okay.
All right. Appoint Attorney Dennis Kirk to represent you. Assuming you have to fill out your financial disclosure form, but there's a problem with that. You set bond for you in the amount of $1,000 plus an OR, which is your cost to appear. Failure to appear, you could be prosecuted for additional penalty and convicted and sentenced on that. In addition, be sentenced in this case. You require a clear deposit of $171 for certain statutory required fees prior to being released. You make bond your report to Mr. Balzer or Ms. Kelly, 117 East Main Street, Hillsborough, immediately upon your release. We'll set a hearing on this, or pick about 10. I gotta check to see if the calendar is anything on here on 10. So Wednesday, you know, we have a trial tomorrow. August 10th for PD there. I think Wednesday. After Friday. So we have a ring answer. Is that Tuesday? Okay. Do 1:30. Okay. All right, so it'll be August 10th at 1:30 p.m. If you make bond, you should contact your attorney, notify him of this private you make bond, you're still on community control, so you need to report, as I said, immediately upon your release, and then report that they tell you comply with all the other conditions that we previously ordered until that time. Now, do you have any questions?
Is it $1,000 to get out? Do I have to have a bondsman, or how does that work?
$1,000 cash, surety, property, plus $171 deposit for the statutory fees.
Thank you.
All right, thank you.
This was my approach.
Right? This is case number 21 CR 054, State of Ohio versus Austin Reed Lightner, present for the state's Assistant Prosecutor Matt King, present for the defense Daniel Witt. Are you Austin Reed Lightner?
Yes, sir.
Mr. Lightner is charged with grand theft of firearms, third-degree felony, and theft, a first-degree misdemeanor. Now, we're here on the bond review hearing. The court, based upon affidavit filed by Officer Arjima, the probation officer, on the 12th of July, filed a habeas for the arrest of the defendant due to his failure to comply. He had reported since June the 8th, allegedly, and also had been referred for an evaluation and another chance in Greenville after he had a positive screen from that, and there had been no proof that he had provided that. And the court also noted that in previous hearings it had been noted that the defendant had issues in terms of reporting and the court issued that order due to the fact that there was an issue about him being contacted as a attorney. So the reason that he's before the court today is to determine what bonds should be in this matter. Now, Mr. Lightner, I've actually been presented now with a plea guilty form, which indicates that you're going to withdraw your not guilty, plead guilty to the charge. And it's a 3-page document the prosecutor's office has prepared. And on page 3 of their signature lines, and I see the attorney's signatures there. And up near the top of the page, left-hand side, there's a sentence that says, "I enter this plea voluntarily." Below that, there's a signature, which is kind of small, so I'm having a little difficulty reading that. But did you sign this plea agreement that I'm looking at here?
Yes, sir, Your Honor.
Did you just sign it here this afternoon? I saw that you saw it with Mr. Witt back in the jury.
Yes, sir.
All right. And did she explain everything to you and what the terms of it were and answer any questions you had?
Yes, sir.
You understand that, that this document is an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case would be a sentencing hearing.
Yes, sir.
Now, have you had enough time to fully consider this matter before making this decision?
Yes, sir.
And then again, I know you were arrested, looks like you were arrested on the 28th. Today is the 29th, so it's been yesterday. And is today the first time you had a chance to talk to Ms. Witt about this document?
Yes, sir.
Do you feel you're being rushed, pushed in any way into doing this?
No, sir.
And, I didn't have you taken into custody just to get you to talk to your attorney and plead guilty. I mean, this was just simply a question for bond. So, if you don't feel comfortable going forward with this today, that's no problem. Okay? I just want to make sure you're okay with that.
Yes, sir.
All right. Now, did you actually talk with Ms. Witt previously about the state's offer on the pleas in this case?
Yes, sir.
All right. So this is not something that's a surprise to you?
No, sir.
Okay. Are you entering into the agreement to plead guilty voluntarily?
Yes, sir.
Right. Now, the agreement states on page 1 that you're going to withdraw your not guilty plea, plead guilty to the charge of grand theft of a firearm under 2913.02A1, a third-degree felony. Further states that you understand that the maximum possible penalty for that would be 36 months in prison if one prison term is imposed. If one is imposed, the minimum would be 9 months. There's a fine available of up to $10,000. And it's not required that you be sent to prison, although in this case, there's a presumption that that is the appropriate sentence, but it's not mandatory. You understand that?
Yes, sir.
Now, are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on probation, community control, parole, or post-release control from any jurisdiction?
Probation, sir.
Where?
Here in Highland County.
In this case?
Yes.
Okay, well, this is just pre-trial supervision. Probation is if you've been convicted in another court and are being supervised under that.
I just moved it. I was placed on felony house arrest, and I was to report to Eric Argentina.
Yeah, I know, that's in this case, but I'm talking about any other case.
Oh, no, sir.
Okay.
Oh, yes, sir. My bad. Misdemeanor case with the other courthouse. It was just probation and community service.
All right, but no other felonies.
Oh, no, sir.
All right. Now, under the law, as I indicated to you, Mr. Leitner, you could be sentenced to prison, and if that occurs, then once you complete that prison term, the law provides that part of the sentence could be the option of the adult parole board putting you under post-release control supervision once you've completed any sentence imposed by the court. And again, that's optional, it's not mandatory, but the parole board makes that decision, not the court. If they decide to put you under post-release control supervision, you will be supervised by a parole officer in a term established by the parole board. And if they determine while you're being supervised, again, that could be up to 3 years, that you have failed to comply, then the parole board could return you to prison, making sure an additional period of incarceration for failing to comply of up to 9 months for any one violation, but there is a cap or limit of half of whatever the prison term was that was imposed by the court for one or more violations. However, if you're convicted of a new felony while you're under post-release control supervision, then in addition to whatever sentence the judge in the new case can impose upon you, the judge is also authorized to sentence you in this case for committing a new felony while under post-release control supervision to an additional period of 1 year, whatever time left on the period of post-release control. In this case, if that occurs, it has to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
Now, as I indicated to you, this offense does not require me to sentence you to prison, although there's a presumption that that's the correct sentence. And so I could, instead of sentencing you to prison, put you in what's called community control or probation. And that could be for up to 5 years. That would be under written terms that are set by this court. And the probation department would be the one supervising you. That could be for up to 5 years. Now, if during the period of time you're being supervised, the probation department felt that you were not complying, they would file a notice of that with the court in writing, serve a copy on you, and then you would be entitled to have a hearing and to be represented by an attorney at that hearing. If the outcome of that hearing was that you failed to comply, then at that time the court could revoke your commitment control and then sentence you to prison for 36 months and fine you $10,000. Do you understand that?
Yes, sir.
Right now, the charge alleges in count 1 that on or about February 5, 2021 in Highland County, Ohio, you did with purpose to deprive Colin Leitner, the owner of his property, knowing that pain or control over said property, with American Tactical AR-15 with 4 magazines, Remington 1911 R1S, I don't know what that means, a 45 caliber Savage Arms 22 LR, and that means long rifle for the scope, Ruger 1022, property being firearms is defined in ORC section 2923.11, without the consent of Colin Leitner, the owner of the person authorized to give consent, in violation section 2913.02A1. So that is the charge of grand theft of firearms, third-degree felony, penalties that I just described for you, if you're convicted. Now, do you understand what the state has accused you of having done, when, where, and how they allege that you did it?
Yes, sir.
And have you discussed the nature of the charge, the evidence of the case, possible legal issues of the case, possible offenses you try to raise in trial, possible outcome of the trial with your attorney?
Yes, sir.
Are you satisfied with your advice and confidence in this matter?
Yes, sir.
Now, are you under the influence of any type of drugs or alcohol at this time?
No, sir.
Have any threat, what, do you take the prescription drug?
I'm supposed to be taking lithium for bipolar disorder, manic depression, and something else, but I don't take it.
When's the last time you took it?
When they prescribed it to me.
Well, how long ago was that? I mean, I saw in one of the reports that you were prescribed lithium, but I didn't see that you tested positive for it.
It was like 2017.
Oh, so you haven't had it for several years?
No, sir.
Oh, okay. All right. But you're able to understand everything I'm saying to you and
Yes, sir.
to relate your thoughts accurately and read and understand what's going on?
Yes, sir.
Okay. Now, has anyone threatened you to get you to plead guilty here today?
No, sir.
And now, the plea agreement has on page 2, 3 lines that are, 2.5 lines that are printed in bold and underlined, so I'll read those. Defendant shall enter plead guilty to count 1, state will dismiss count 2, state defense jointly recommend control, defendant agrees to cooperate fully in the prosecution of the co-defendant. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, Mr. Leitner, the matter of sentence is reserved to the court, not to the parties. So even though the prosecutor and you and your attorney are all saying that the sentence should be community control or probation, doesn't mean that I have to do that. If I decide after I've heard all the information presented that that's not the proper sentence, I could go ahead and sentence you to prison for a period of between 9 and 36 months in the increments provided by law, and the increment in between there, I should say, and fine you $10,000.
Yes, sir.
You understand that?
Yes, sir.
Okay. Do you hold any license or certification from any state agency or board for any kind of an occupation or profession?
No, sir.
Okay, now you have certain constitutional rights you must understand before I can accept this plea from you. First of all, you have the right to have an attorney, this witness was appointed to represent you because you could not afford to hire an attorney. Now, I didn't appoint her simply to work the case out, but to provide any defense that could be available to you under the law that you wish her to provide. So if you don't want to do this, she'll continue to defend you in the case, including having a trial if that's what you want. You understand that?
Yes, sir.
I know, Mr. Leitner, in the Constitution, you have a right to a jury trial in this matter in which 12 people will be selected from a group of citizens from this county who will be summoned for jury duty on your trial day. After they were selected, the evidence would be presented, they'd be instructed on the law by the judge, and that jury would have to decide by unanimous verdict. All 12 would have to agree as to whether or not the state proved your guilt of the offense. Now, if you didn't want to have a jury trial, but you did not want to plead guilty, you can waive in writing, and waive in this sense means, in the legal sense means to give up your right to have a jury trial. And in that case, you would have a court or bench trial, which means the judge would be the one to hear the evidence instead of the jury, apply the law, and decide whether or not the state proved your guilt, proved beyond reasonable doubt. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to confront the witness against you and cross-examine them through your trial. So, if there are witnesses, whatever witnesses the state has to come in court, testify in front of you and your attorney, whoever else may be here, because it's a public proceeding. Once the prosecutor is done asking those questions, then your attorney can ask questions. That's called cross-examination. And the reason for that is to try to bring out evidence and help your side of the case. You understand that?
Yes, sir.
And under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. So, if you have witnesses you're not certain are going to come in voluntarily, you request a court order, issues a court order, that's a subpoena. And that would force those people to come to court to testify for you if you wanted them to, even though they don't want to be here, which is the same way that the state's witnesses are forced to come in and testify against you. You understand that?
Yes, sir.
Right now, Mr. Leitner, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make a testimony. The prosecutor can, the judge can, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings, and in fact, no one's even allowed to talk about it except in one situation, that is if there's a jury trial you want to testify. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
And Mr. Leitner, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is that the burden of proof isn't on you to prove you're not guilty simply because you've been accused of this crime. In fact, under the law, you don't have to present any evidence in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of the offense charged by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
All right, now, Mr. Leitner originally entered a plea of not guilty, which denied the allegations in the indictment, denied you committed any crime, and it exercised or invoked all the rights I just described. Change your plea from not guilty to guilty, that would, as to count one, that would be the opposite of not guilty plea. The guilty plea would admit the allegation and count one, admit that they're true, admit that they're a crime, that you committed that crime, and that plea would waive or give up all of the rights that I've previously explained to you here today, except your right to have an attorney. You always have a right to have an attorney no matter what you plead. But with that exception, your plea of guilty waives gives up the right to have a jury or court appointment. Waives gives up the right to brought witnesses against you and cross-examine through your attorney. Waives gives up the right to use the power of the court, the power of force witnesses to come to court to testify for you, the same as the state. The waives gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It also waives gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives gives up your right to file an appeal if you think that you have had any right to do that up until this point in the case. Now, if you are sentenced to maximum sentence, or under certain circumstances you could file an appeal. Any appeal that you would file would have to be filed in 30 days of the sentence and entry being filed. You understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
All right, now, Mr. Leitner, you have any questions about the charge of possible penalties?
No, sir.
You understand?
Yes, sir.
Any questions about the plea agreement?
No, sir.
You understand that?
Yes, sir.
Any questions about the constitutional rights I've explained?
No, sir.
You understand them?
Yes, sir.
Any questions about the plea of guilty, what it means, what will happen if that plea here today?
No, sir.
You understand?
Yes, sir.
Is there anything more you need to talk with Ms. Witt about before we go any further?
No, sir.
And is it your decision to withdraw your not guilty plea, plead guilty to count one in accordance with the terms of this agreement that I've just gone over with you?
Yes, Your Honor.
Then as to count one, Ms. alleges that on or about February 5, 2020, Highland County, Ohio, that Chase Anthony Jones and you did with purpose to deprive Colin Leitner, the owner of his property, not only obtain or exert control over said property to wit an American Tactical AR-15 with 4 magazines, Remington 1911 R1S IN, 45 caliber Savage Arms 22 LR with scope, Ruger 1022. Property being firearms is defined in ORC section 2923.11 without the consent of Colin Leitner, the owner of person authorized to give consent in violation of section 2913.02A1, charge of theft of firearms, third-degree felony, which carries a possible prison term of between 9 and 36 months in certain increments provided by law, and a fine of $10,000. How do you plead?
Guilty, Your Honor.
Thank you. I didn't ask, as the state consultant with the victim of this offense.
Yes, Your Honor, the victim is actually his brother, and he is an approved witness.
Okay, I kind of gathered that and inferred that. Okay. Thank you. Right, the court finds on this day open court, defendant was advised of all his constitutional rights, made no intelligent voluntary waiver of those rights pursuant to Criminal 11. Please accept it or file. Defendant is found guilty of count one. The second count is dismissed. Court will order a pre-sentence investigation, which will include an assessment for substance use disorder and or mental health. Sentencing hearing will be September 1. They're not going to be out of town that day, right?
Yeah.
September the 1st at 9 a.m. Mr. Leitner, there's a recommendation you gave committee control here, and I don't believe you have a prior felony conviction, do you?
Yes, sir.
Right. And so there's a pretty good chance that that will be the sentence of the court, despite the fact it's a felony. But, right now you haven't done a whole lot in terms of being compliant. Now, I'm going to release you on your ORO. You must report as soon as you get released today to the probation department. And you need to get there by 4. I think you'll be able to make it, but you need to call them in jail and let them know that if they tell you to come in tomorrow, that's fine. But you need to report to them and make an appointment for a pre-sentence interview. And also, they previously told you to be assessed, Real Associates, because you live in Greenville, right?
Yes, sir.
The purpose of that is, if you've had a history, mental health history, you may need some evaluation for that, possible treatment, I don't know. And also, since you tested positive for meth, you need to be assessed for substance use disorder treatment for that. So I'm going to go ahead and release you. I'm going to let you know right now. And if you don't comply, and if you quit reporting, and don't cooperate, the law says I ought to send you to prison for this offense. So for me to get justification for not doing that, I have to have some proof of you that you're going to comply with your supervision. You haven't done a very good job so far. Now's the time to get the message and change and do what you're told. Because, I'm not your mom. You can ignore your mom or your dad. But, you can ignore me too, as far as that's concerned. But I carry a lot more punch than your parents do. So I can say it first. So make sure you do it. Do you have any questions?
Yes, sir.
All right. So you're released, and like I said, go to the probation department immediately today. All right. Thank you.